Hello, and welcome to S&C's Critical Insights. I'm Kamil Shields, a partner in the firm's litigation group and a member of the Criminal Defense and Investigations group. Joining us today from our Palo Alto office is Kyle Mack, a partner in our antitrust group and a former deputy director of the FTC's Bureau of Competition.
Hi, Kamil. Nice to see you.
Likewise, Kyle. Today, we're going to continue our Critical Insights series, and we've been focusing on whistleblower developments that are affecting our clients. During our last episode, Annie Astraker, a partner in the firm's litigation group, and I provided some background for this series, addressed the recent downward trend in SEC whistleblowing enforcement, and explored the growth of whistleblower regimes as a means of pursuing investigative priorities. And if you missed that episode, and it was a great episode because it was a kickoff to our series, you can find it in the S&C Critical Insights library. So as with our prior discussions, Sabrina Solow, an associate in our litigation group, will moderate. So we're going to kick off today with a bit of brief background on antitrust law. We'll have Kyle do that. Then we'll explain the Antitrust Division's new whistleblower program and how this reflects a change in the division's approach. And finally, we'll discuss ramifications for our clients. So with that, Sabrina, can you kick it off for us?
Yes. Thanks, Kamil. And it's great to join you both today. Before we dive into the new program DOJ Antitrust has developed, Kyle, could you share some high-level background on U.S. antitrust law, please?
Sure, I'm happy to. So at the highest level, the U.S. antitrust laws are designed to promote competition. So the laws aim to prohibit anti-competitive business practices like monopolization that was acquired through anti-competitive means, cartel, other types of activities that improperly restrain trade or reduce competition in the marketplace. And one of the most foundational pieces of legislation in connection with the antitrust laws is the Sherman Act of 1890. The Sherman Act actually reaches a very wide range of conduct in the marketplace, but it clearly prohibits agreements that obviously restrain trade and can hurt consumers. Those are things like price fixing, market allocation, or bid rigging. The antitrust laws are enforced by both the Department of Justice and the Federal Trade Commission, but only the Department of Justice can bring criminal penalties, which can attach to certain categories of antitrust misconduct. Civil liabilities, meaning claims brought by civil plaintiffs in federal courts or other courts, can also attach a variety of anti-competitive conduct. So let me define a couple of specific terms now that will become more important later when we talk about the new program. The first is bid rigging, which occurs when competitors collude to manipulate the outcome of a bidding process, therefore undermining fair competition in that process. Price fixing, meanwhile, involves an agreement between competitors to set prices at a certain level instead of allowing market forces to determine what the prices would be independently. Market allocation involves agreements between competitors to divide a market, such as by splitting customers by geography or other features.
Thanks so much, Kyle. That background's really helpful. Kamil, we've been hearing a lot about the Antitrust Division's new program offering monetary awards to whistleblowers for tips on criminal antitrust violations. Could you speak to the genesis of this program and how it fits into existing DOJ antitrust policies?
Sure. So since the 1990s, the Antitrust Division has had a leniency policy. Broadly speaking, what that means is that when an organization or individual is the first report that it has engaged in a criminal conspiracy, it can receive non-prosecution protection. In other words, that the Department of Justice will be lenient if they've been the first reported. Under the Antitrust Criminal Penalty Enhancement and Reform Act, which is a bit of a mouthful, so we'll call it ACPARA, the first report these conspiracies can also receive a variety of benefits in related civil litigation as well. This leniency policy is an important enforcement tool for the Antitrust Division. It creates a powerful incentive for companies and individuals to self-report in order to avoid or mitigate criminal prosecution and penalties. About a month ago, on July 8th, the DOJ Antitrust Division announced a partnership with the U.S. Postal Service to create a whistleblower rewards program for reporting criminal offenses on, quote, antitrust crimes and related offenses, end quote. Under this program, whistleblowers who voluntarily provide information about antitrust offenses that result in at least $1 million recovery may be eligible to earn a reward. which is presumptively 15 to 30% of the amount of the fine or recovery. And we're going to dive into some specifics, as Kyle noted, about this program shortly. Notably, this is the first time that the Antitrust Division will offer a financial reward for tips on antitrust crimes. And it's the first time any whistleblower program has been used to identify violations of the antitrust laws.
Interesting. How does this new rewards program fit into an emerging pattern of expanding DOJ whistleblower programs?
Well, the trend line pretty clearly suggests DOJ views whistleblower programs important tools that go above and beyond the leniency and other programs that they have in place today, and that those programs can be used against white-collar crime, including criminal enforcement of the antitrust laws. For example, in 2024, the DOJ Criminal Division launched a program we call the Corporate Whistleblower Awards Pilot Program, which we'll discuss in more detail in the next episode. Relatedly, in May, the DOJ launched a civil rights fraud initiative to encourage whistleblowers to file key TAM actions under the False Claims Act. So what we see here is an overall pattern of using more and more of these programs to address the agency's priorities.
That's right, Kyle. And if I can break in really quickly, I want to note that we have produced a number of client memos on these topics. And in addition to these podcasts, we've been producing memoranda and a number of other fact materials related to whistleblower programs across the Department of Justice, as well as the SEC and other enforcement agencies.
Great, thanks both. Let's turn to the nitty-gritty of the new program. What are the eligibility requirements of this new program?
The key eligibility requirements are, first, the tip that's received by the agency has to relate to what is called an eligible criminal violation. Second, the whistleblower has to provide original information. And three, there must be a nexus to the U.S. Service in order to qualify. Turning to the first requirement, the requirement that it apply to an eligible criminal violation, the whistleblower must provide information relating to an eligible violation of the antitrust laws. It can't be a tip on any sort of criminal violation. The MOU identifies several broad categories of criminal violations that presumptively qualify for the program. Criminal violations of the Sherman Act, like price fixing, bid rigging, and market allocation that we discussed earlier, would qualify, as do criminal violations to effectuate or hide other Sherman Act violations. Other criminal investigations include those that target or affect federal competition proceedings or investigations, as well as those that affect public procurement at the federal, state, or local level.
Thanks, Kyle. And Kamil, I know you talked about this with Annie in the last episode in the context of the SEC's program, but how does this rewards program define original information?
Thanks, Sabrina. And original information is obviously important because, as we discussed, what these agencies are looking at are rewarding whistleblowers. So individuals that are providing new information that's unknown to the agency. So in connection with the Antitrust Division's whistleblower program, there are 2 pages in their MOU with the Postal Service addressing what constitutes original information. Generally, a whistleblower must provide, quote, truthful and complete information that isn't already known to the Antitrust Division or the Post Office, and it must derive from, quote, independent or unique knowledge.
Great. So it sounds similar to the SEC's definition of original information. Are there any noteworthy differences with respect to the Antitrust Division's definition?
Well, as I said, Sabrina, there are 2 pages in the MOU that are devoted to original information and independent knowledge. It's a bit more complicated than some of the other whistleblower regimes that we've seen. And whether or not something is original, the MOU sets out 2 different standards for that. First, someone who is an officer, director, or compliance or audit person can, in limited circumstances, become an original source. This happens, though, under a pretty complicated set of circumstances, which are, as I said, laid out in the MOU. For example, take someone who obtains original information because they were an officer or director, and someone else informed them of allegations of misconduct. If that officer or director themselves provides the information to the chief legal officer or the chief compliance officer, among other supervisors, or received information under circumstances indicating that the chief legal officer or the chief compliance officer was already aware of the information, and at least 120 days have elapsed, then that individual, the officer or director that we were speaking of, now has original information. Second, if an individual first internally reports original information and the entity then reports to the Antitrust Division's the individual's information or the results of any internal investigation that the entity does that's initiated by that internal report, then so long as the individual reports to the division within 120 days of providing that internal tip, the division counts the individual's internal reporting date as the original disclosure date to the division. Basically what this means, and again, it's laid out in the MOU, is that companies knowing that individuals reporting internally have an incentive to report externally within 120 days, so the individual remains the, quote, original source. These are two different 120-day rules and have different implications. So companies need to treat them separately, but most importantly, become aware once they are on notice of internal reports about misconduct to make sure they're paying attention to these 120-day guidelines.
Thanks, Kamil. And what about the third eligibility requirement, requiring a nexus to the Postal Service?
Right, and I think this has been one that have a lot of questions for people. The program, as we noted at the outset, is a joint effort between the Antitrust Division and the Postal Service, because it's the Postal Service that has the existing statutory authority to pay whistleblowers. So in order for this new program to fall under that statutory authority, the tip must allege activity that affects the Postal Service, its revenues, or property. This is pretty broad. So basically, the tip will mean any tip will reach this bar of affecting the Postal Service and its revenues or property, where the Postal Service concludes that the Postal Service, has suffered an identifiable harm. But importantly, that harm need not be material or otherwise pose any substantial detriment to the Postal Service.
This limit may not actually restrict the program all that much, but we'll see as the program gets up and running whether the program actually meaningfully limits what happens in practice.
Great, thanks. Let's wrap up. What are your takeaways?
Well, I think it's interesting. Although the division's leniency policy historically has been quite effective, this new rewards program does expand the Antitrust Division's toolkit for detecting collusive activity. And unlike the leniency program, this whistleblower program applies only to individuals, and it offers the potential for direct payouts instead of the opportunity to escape potential future fines. Also, like other whistleblowing programs, and we've seen the success of these programs, the rewards program may improve the Antitrust Division's access to certain key facts by providing, as we've noted, an incentive for whistleblowers to come forward.
Right. The program really targets one of the biggest challenges that the agency faces, at least early in the stages of an investigation. And that is figuring out whether there was an actual agreement that violates the Sherman Act, as opposed to some other kind of conduct that doesn't quite reach that standard, but also putting them in a position to figure out who might be able to testify as to the existence of that agreement. In other words, the new program really could make it much easier for the government to clear the initial hurdles of their fact investigation and address issues that can be quite difficult for the government to prove. All of this has important implications for companies trying to achieve internal compliance with the antitrust laws. It just means that in addition to trying to literally comply, they have to be thinking about the possibility that an employee wrong might go to DOJ and report antitrust violations. I do think that it could lead to an increase in criminal antitrust investigations and prosecutions, and in-house lawyers and compliance officials need to be thinking about that risk.
That's right, Kyle. And I think it's a risk that folks, again, in these kinds of functions need to be thinking about not only in connection with the Antitrust Division's new program, but those other DOJ programs that we've already discussed and will discuss in future episodes, as well as programs by the SEC. So it'll be interesting to see how this program fits within that broader regulatory framework that we've been obviously addressing and assessing as part of this series.
Thank you for listening to S&C Critical Insights. We hope you tune in to our next episode in this series, in which S&C partners Nick Borton and Annie Ostrager will discuss whistleblowing under the DOJ's evolving corporate pilot program, the 2020 Anti-Money Laundering Act, and the FCA's Key TAM Act provision. For more information about our practice, please visit us on the web at www.silcrom.com.